Okay, my name is Paul Troop. I'm a barrister, which is a specialist advocate and legal consultant. I practice for Tooks Chambers. I've been practicing for about 10 years. I practice in human rights, civil liberties, and I do a lot of international law. So I'm a defence counsel for International Criminal Court and the Yugoslav Tribunal, so I've done a couple of war crimes cases. I also do domestic cases where there's an international element. I've worked in the occupied territories several times, and I've tended to do cases in the UK which raise issues related to Israel Palestine or issues of international law. So what I thought I'd do was to talk about two types of cases where the Goldstone report has been coming up, just to give you an idea of how lawyers might use the Goldstone report. One of those is universal jurisdiction. Universal jurisdiction is something that Alistair spoke about, and that means normally there's a principle of sovereignty, so only a state can only exercise jurisdiction within its own borders. But over history there were certain offences which were exceptions to that, like piracy, where you could prosecute pirates even though the piracy took place outside your own state for good reasons. And over the years, particularly serious crimes like war crimes and crimes against humanity have been recognised, at least in principle, as crimes of universal jurisdiction. So if you look at, for example, the Convention Against Torture or the Fourth Geneva Convention and the provision on grave breaches, there's an obligation on each state as a signatory to either prosecute someone suspected of committing those crimes, even if it wasn't a citizen of their state, even if the person committed those crimes outside the state, provided there's some way of that person being within the jurisdiction, say they're visiting or living there. The alternative, if you don't prosecute, you're obliged to extradite them to a state where they will be prosecuted. So those are the obligations.
So I've heard someone talk about this before, and they said that what that means is that theoretically Israeli diplomats or government officials could be arrested on entering another territory, say England, and then died there or deported somewhere else.
That's right. In the UK, we have a law called the Geneva Conventions Act, 1957, which. Still there?
Yeah, we're still here. I was just hanging up.
Okay, good. We've got a law called the Geneva Conventions Act, 1957, which permits any grave breach of the Geneva Conventions, and you've heard several this evening. One of the main ones is willful killing. So if you deliberately kill a civilian, that's the war crime of willful killing. There are several others. Probably another that's relevant is the war crime of wanton destruction of property, another one which took place on a very widespread basis in Gaza. And either the states can prosecute, or, as with any other offence, a private prosecutor can bring prosecution. Obviously, in relation to several states, the US, Israel and the European countries, the government is really unwilling to bring its own prosecutions. So what's happened in the past is that myself and others have been involved in cases where we have sought to initiate a prosecution with a view to bringing a private prosecution. The only successful case that there's been is the case of Doron Almog, which I was the junior in that case. And we persuaded a magistrate that there was jurisdiction and that the person, Doron Almog, didn't have immunity and that a warrant should be issued. We were successful in that. But because of the great unwillingness of the police and the authorities to actually act in accordance with the law, a huge number of individuals were tipped off about this arrest warrant, and as it turned out, the Israeli military attaché was informed. The plane that Doron Almog was on landed. The military attaché boarded the plane. Doron Almog didn't get off the plane. The police who were waiting at immigration control, even though they legally have the power to board a plane, and they knew very well that that they could board the plane, and we know this because the particular officer involved was videoed, was on some kind of TV program a few months beforehand, being recorded boarding a plane, so he clearly knew that he had the power to board the plane. They gave various ridiculous reasons why they shouldn't board the plane, such as they feared a shootout or all sorts of things. But the upshot of it was that the plane took off without Don Almond being arrested. Now that's the only successful application, I think, under the Geneva Conventions Act. There have been various other attempts, some of them more or less successful, more or less serious. Some of them have just been publicity stunts, where it's quite clear, for example, that the person has immunity. If there's immunity, that's almost an absolute bar of getting an arrest warrant. So that's one way which the Goldstone report can be used. It's quite helpful because it does specifically recommend the use of universal jurisdiction. It also talks about the things which are relevant to the issue of a magistrate issuing a warrant, such as impunity in Israel. Generally, courts are very willing to allow a private prosecution if there's another jurisdiction which is better suited to the case to be brought forward. But as the Goldstone report makes quite clear, it's almost impossible, or it's just simply not going to happen. There are serious allegations are going to be properly investigated. So that's a big factor, in fact, in favour of a magistrate exercising its jurisdiction. So that's the one thing. The second one is more using it in a defensive capacity.